The indictment further alleges an offence of cruel treatment against 2 victims. Similar allegations relating to a 3rd victim were dismissed in the Chamber's decision on Rule 98 bis. The elements of the crime of cruel treatment have been established against the actual JNA perpetrators. Offences of unlawful attacks on civilians and on civilian objects are also charged. On 6 December 1991, the evidence is unequivocal that the Old Town was, as it still is, a living town. Though a world-protected heritage site, it has a substantial resident population of between 7,000 and 8,000. As stated earlier, the Chamber has found that the Old Town was extensively targeted by JNA artillery and other weapons on 6 December 1991, and that no military firing points or other objectives, real or believed, in the Old Town were targeted by the JNA. In the Chamber's finding, the intent of the perpetrators was to target the civilian population and civilian objects in the Old Town. The elements of these 2 offences have therefore been established against the actual JNA perpetrators. With respect to the crime of devastation not justified by military necessity and the crime of destruction of cultural property, the allegation against the accused following the Rule 98 bis decision was that damage or destruction was sustained by 116 specified buildings and structures in the course of the 6 December shelling of the Old Town of Dubrovnik. The Chamber finds that of those 116 buildings and structures, it has been established that 52 were damaged, 6 of them being destroyed during the 6 December shelling of the Old Town by the JNA. The nature and extent of the damage to these buildings varied. Moreover, while several of the 52 buildings and structures had sustained some degree of damage from earlier shelling in October and November, the Chamber is satisfied that the previously damaged buildings sustained further and significant damage during the 6 December attack. In relation to the charge of devastation, the Chamber finds that the Old Town sustained damage on a large scale on 6 December 1991. In relation to the charge of destruction of cultural property, the Old Town of Dubrovnik in its entirety was entered onto the World Heritage List in 1979, so that every building of the Old Town, including its walls, are properly characterised as cultural property. It has also been established that there were no military objectives in the immediate vicinity of the 52 buildings and structures destroyed or damaged on 6 December 1991, or in the Old Town or in its immediate vicinity, so that the destruction or damage of property in the Old Town on 6 December 1991 was not justified by military necessity. The elements of these 2 crimes have been established against the actual JNA perpetrators. The Chamber now turns to the crucial question whether the accused is proved to be personally criminally responsible for the artillery attack on the Old Town, or indirectly criminally responsible as commander of the 2OG for the conduct of the JNA troops who were the actual perpetrators of these offences. It is established that all the JNA forces involved in the military action at Dubrovnik on 6 December 1991 were components of or subjugated to the 9 VPS which was commanded by Admiral Jokic on 6 December 1991. Further, the 9 VPS was in turn under the operational command of the 20G, which was commanded by their accused. As their superior commander, the accused had both legal and effective control of the JNA forces which conducted the military action at Dubrovnik, including the shelling of the old town. The evidence does not establish, however, that the accused ordered the shelling of the old town, which occurred on 6 December 1991. What is established is that the accused did order the attempt to capture Serge, which was undertaken on 6 December 1991. In the written judgment, the Chamber has dealt with the evidence which establishes this, and also some evidence which sought to suggest that this was not so. In particular, the Chamber accepts the evidence of Colm Doyle, then in charge of the ECMM monitors in Bosnia and Herzegovina, of a conversation he had with the accused on 6 December 1991, shortly after midday, the effect of which, in the finding of the Chamber, was an admission by the accused that he had ordered the attack on Serge. The actual words of the accused could be understood to suggest he ordered the shelling of the old town, but for reasons set out in the written judgment, that is not the finding of the Chamber. The accused, however, left the detailed planning of the attack on Serge to the 9 VPS, whose forces surrounded Dubrovnik, and this is what occurred on late 5 December 1991. While the circumstances known to the accused at the time of his order to attack Serge can only have alerted him to the possibility that, as had occurred in October and November, his forces would once again ignore orders and resort to deliberate and indiscriminate shelling, especially of the old town, it has not been established that it was known to the accused that at the time of his order there was a substantial likelihood of this occurring. It has not been proved, therefore, that the accused is guilty of ordering the attack on the old town. The Chamber finds that it has not been proved that the accused aided and abetted the unlawful shelling of the old town. In particular, while the accused did not take all necessary and reasonable measures to ensure that the shelling ceased, he did issue a ceasefire order to take effect at 11:15 hours, although this order was not implemented effectively. Further, the necessary mental element for aiding and abetting is not established. It has not been proved, therefore, that the accused is personally criminally liable for the attack pursuant to Article 7.1 of the statute. We now deal with the accused responsibility as commander of the 20G pursuant to Article 7.3. On 6 December 1991, the accused had the legal authority and the material ability to issue orders to the 3rd Battalion 472nd Brigade and all the other JNA forces involved in the attack on Serge and the shelling of Dubrovnik, including the Old Town, to ensure that the Old Town was not shelled and that an existing attack ceased. In the Chamber's finding, from about 0700 hours on 6 December 1991, the accused was on notice because of events detailed in the written judgment of the clear and strong risk that already his J&A artillery was repeating its conduct and shelling the Old Town. By that time, the risk that this was occurring was so real and the implications were so serious that the accused should have seen the urgent need to determine whether the J&A artillery was in fact shelling the Old Town without justification, and if so, to ensure the attack on the Old Town was stopped. He did not do so. In particular, the finding of the Chamber is that the accused did not give an order to Admiral Jokic at about 0700 hours on 6 December 1991 to stop the attack on Serge. The Chamber has already indicated that an order to cease fire with effect from 11:15 hours was given to some J&A artillery units, but not all, and the troops trying to capture Serge were not ordered to cease their attack at 11:15 hours. The evidence further establishes in the Chamber's finding, and despite strong submissions to the contrary, that after the attack, the accused at all times had full authority to act himself, to investigate and to take disciplinary or other adverse action against the perpetrators of the attack on the Old Town, and also to require Admiral Jokic to take more effective measures. Despite this, the accused chose to take no action of any type. The Chamber is therefore satisfied that the elements required for establishing the accused's responsibility under Article 7.3 of the statute, as the superior commander of the J&A forces who perpetrated the unlawful shelling of the Old Town on 6 December 1991, have been proved. He failed to stop the attack on 6 December when he could and should have done so, and afterwards he failed to ensure that the perpetrators were punished. In the present case, the elements of each of the 6 counts in the indictment have been established. The Chamber observes, however, that the essential criminal conduct was an artillery attack against the Old Town. In the course of that attack, civilians were killed and injured, and protected buildings were damaged and destroyed. It is the view of the Chamber that the essential criminal conduct is directly and comprehensively reflected in counts 3 and 6, and that the interests of justice and of sentencing are fully satisfied if convictions are recorded only for those 2 offences. General Strugar, would you please stand? The Chamber finds you guilty, pursuant to Article 7.3 of the statute, of the following 2 counts. Count 3, attacks on civilians, a violation of the laws or customs of war under Article 3 of the statute. and count 6, destruction or willful damage done to institutions dedicated to religion, charity and education, the arts and sciences, historic monuments and works of art and science, a violation of the laws or customs of war under Article 3 of the statute. While the Chamber is satisfied that the elements of the following 4 counts have been established pursuant to 7.3 of the statute, the Chamber does not record a finding of guilty against you in respect of count 1, murder, count 2, cruel treatment, count 4, devastation not justified by military necessity, and count 5, unlawful attack on civilian objects. Further, the Chamber does not find you guilty pursuant to Article 7.1 of the statute in respect of any one of the 6 counts. The Chamber has set out in some detail in the written judgment the factors it has taken into account in determining sentence. In particular, it has been conscious of the serious nature of the attack on the old town of Dubrovnik and the consequences for its inhabitants and for the cultural properties damaged or destroyed in the attack. The Chamber would emphasise that you are not to be sentenced for ordering the attack on the old town. Your criminal liability arises because you failed to take adequate measures to stop the shelling of the old town and because you failed to ensure that those responsible for the attack were disciplined. In these regards, you were not the immediate commander of those responsible. That was Admiral Jokic. You were Admiral Jokic's superior and therefore one step further removed. The Chamber takes into account that Admiral Jokic has pleaded guilty to offences arising from his part in the attack on the old town and has been sentenced to 7 years imprisonment. The Chamber takes into account in particular your age and health, which is deteriorating, and other mitigating factors which have been set out in the written judgment. The Chamber hereby sentences you to a single sentence of 8 years imprisonment. You can sit down. The accused has been in custody for 457 days. Pursuant to Rule 101C of the rules, he is entitled to credit for the time spent in detention so far. Pursuant to Rule 103C of the rules, the accused shall remain in the custody of the tribunal pending the finalisation of arrangements for his transfer to the state where he will serve his sentence. The hearing is adjourned.
All rise, veuillez vous lever.